Autobus Transport Systems, Inc. vs. Antonio Bautista. May 16, 2005. Facts. Since May 24, 1995, Respondent Antonio Bautista has been employed by petitioner Autobus Transport Systems, Inc., as driver-conductor. Respondent was paid on commission basis, 7% of the total gross income per travel, on a twice-a-month basis. On January 3, 2000, while Respondent was driving Autobus number 114 along Santa Fe, Nueva Vizcaya, the bus he was driving accidentally bumped the rear portion of Autobus number 124. Respondent averred that the accident happened because he was compelled by the management to go back to Roxas, Isabela, although he had not slept for almost 24 hours. As he had just arrived in Manila from Roxas, Isabela. Respondent further alleged that he was not allowed to work until he fully paid the amount of 75,551.50 pesos, representing 30% of the cost of repair of the damaged buses, and that despite Respondent's pleas for reconsideration, the same was ignored by management. After a month, management sent him a letter of termination. Issues: whether or not Respondent is a field personnel, whether or not Respondent is entitled to service incentive leave. Ruling. The disposition of the first issue revolves around the proper interpretation of Article 95 of the Labor Code vis-a-vis Section 1(d), Rule 5. Book 3 of the Implementing Rules and Regulations of the Labor Code, which provides Article 95. Right to service incentive leave. A. Every employee who has rendered at least 1 year of service shall be entitled to a yearly service incentive leave of 5 days with pay. Rule 5, Book 3, Service Incentive Leave. Section 1. Coverage. This rule shall apply to all employees except d. Field personnel and other employees whose performance is unsupervised by the employer, including those who are engaged on task or contract basis, purely commission basis, or those who are paid in a fixed amount for performing work irrespective of the time consumed in the performance thereof. A careful perusal of said provisions of law will result in the conclusion that the grant of service incentive leave has been delimited by the implementing rules and regulations of the Labor Code to apply only to those employees not explicitly excluded by Section 1 of Rule 5. According to the implementing rules, service incentive leave shall not apply to employees classified as field personnel. The phrase "other employees whose performance is unsupervised by the employer" must not be understood as a separate classification of employees to which service incentive leave shall not be granted. Rather, it serves as an amplification of the interpretation of the definition of field personnel under the Labor Code as those whose actual hours of work in the field cannot be determined with reasonable certainty. The same is true with respect to the phrase "those who are engaged on task or contract basis, purely commission basis." Said phrase should be related with field personnel. Applying the rule on ejusdem generis that general and unlimited terms are restrained and limited by the particular terms that they follow. Point 9. Hence, employees engaged on task or contract basis or paid on purely commission basis are not automatically exempted from the grant of service incentive leave, unless they fall under the classification of field personnel. What must be ascertained in order to resolve the issue of propriety of the grant of service incentive leave to Respondent is whether or not he is a field personnel. According to Article 82 of the Labor Code, field personnel shall refer to non-agricultural employees who regularly perform their duties away from the principal place of business or branch office of the employer and whose actual hours of work in the field cannot be determined with reasonable certainty. This definition is further elaborated in the Bureau of Working Conditions, Advisory Opinion to Philippine Technical Clerical Commercial Employees Association 10, which states that, as a general rule, field personnel are those whose performance of their job service is not supervised by the employer or his representative. the workplace being away from the principal office and whose hours and days of work cannot be determined with reasonable certainty. Hence, they are paid specific amount for rendering specific service or performing specific work, if required to be at specific places at specific times. Employees including drivers cannot be said to be field personnel despite the fact that they are performing work away from the principal office of the employee, as observed by the labor arbiter and concurred in by the Court of Appeals. It is of judicial notice that along the routes that are plied by these bus companies, there are its inspectors assigned at strategic places who board the bus and inspect the passengers, the punched tickets, and the conductor's reports. There is also the mandatory once-a-week car barn or shop day, where the bus is regularly checked as to its mechanical, electrical, and hydraulic aspects, whether or not there are problems thereon as reported by the driver and/or conductor. They too must be at specific place at specified time, as they generally observe prompt departure and arrival from their point of origin to their point of destination. In each and every depot, there is always the dispatcher whose function is precisely to see to it that the bus and its crew leave the premises at specific times and arrive at the estimated proper time. These are present in the case at bar. The driver, the complainant herein, was therefore under constant supervision while in the performance of this work. He cannot be considered a field personnel. We agree in the above disquisition. Therefore, as correctly concluded by the appellate court, Respondent is not a field personnel but a regular employee who performs tasks usually necessary and desirable to the usual trade of petitioner's business. Accordingly, Respondent is entitled to the grant of service incentive leave.